Okay, so blessed day, everyone. This is the additional of our discussion that I previously posted on our Facebook group. So this time, I will make our discussion more comprehensible, and I will expand to discuss those topics covered by the previous discussion. So let us talk again the different police activities. So first, we have the prevention of crime. Crime prevention is intended to prevent root causes of crime. Before the crime is actually be committed, police response intervene that would make the plans of fugitives culprit to be impossible to be committed. So prevention of crime, which you will intervene the possibility that the crime will be committed. So much so, the police officer would conduct a proactive response. Later on, I will discuss the distinction between proactive response and reactive response. The second police activity is the repression or suppression of crime. This is done to reduce opportunity of committing a crime, like the act of conducting patrol that is actually the theory of police omnipresence or police omnipresence theory. It is a police visibility. The presence of police personnel, for example, in the community, would impede the person to commit a crime. For example, pag may nakikita akong mga police officers conducting patrol, well, of course, the opportunity that I should launch or even implement my plan to commit crime would become impossible because I do not want that the police officer will arrest me. And hence, I better find another time in a right prudent in the right time. But if in cases that daily police officer the police officers are conducting patrol 24 hours every day, would may somehow suppress my intention to commit crime. I would say hindi na ako gagawa ng masama, or I will no longer perpetrate my intention to commit crime. So this number 2 is more on proactive nature or proactive response. We do not wait for a crime to happen before we act on it. We launch program or even those police activities that would make person with criminal mind will no longer commit a crime. Like I said, when there is the presence of the police officers, would somehow make a person realize that their opportunity would impede them to commit their plans, for example, to kill someone. While the reactive response, we will wait that there is a complaint saying there is a crime committed before we act on it. Or something happened already, then here comes now our response to deal with that situation and others similarly situated. So in other words, we investigate crimes. Crimes already happened. And that investigation is your reactive response. Would it be better if we do not investigate? There is no crime to be investigated. In other words, there is no crime committed. Of course, you will not conduct investigation if there is no crime committed, isn't it? Okay. Though the number one is also may fall under the proactive response, because these police activities that intended for crime prevention is somehow proactive response as well. And the third police activity is apprehension of offenders, which is also known as arresting offenders rather. They are the executives. They are the one enforcing the laws, not breaking the laws. You might somehow watch or even heard from news about those involvement in engagement of police officers in the criminal activities. Well, of course, those are not in the scope of this police activity, because those police officers are designed not they are not actually designed, they are destined to enforce the laws. That is, when someone committed a crime will of course be arrested. When those circumstances attended by virtue of warrant of arrest or warrantless arrest. And the third one is the conduct search and seizure. When there is a search warrant and the competent court issued a search warrant to a police officer who is competent, who is man to give report within 10 days about the items cited in the search warrant to be searched and confiscated or to be seized. Okay, these are, for example, later on I will discuss search warrant. Okay, so you might already somehow heard from your friends or even from news that the police officers raid, likewise confiscated those lost firearms, for example. Okay, even those contrabands. And the next one is the investigation of crime. Like I said, we conduct an investigation because there is a crime committed. Police officers prove things to know what really and factually happened. And the next one is the protection of lives and properties. The police is one of the agencies representing the state to defend the people, to maintain peace and order, for the people to enjoy the blessings of independence, of sovereignty. Now, it is not, like I said, it is one of the agencies of the government representing the state. So there are many agencies who can likewise perform lives and protection of lives and properties. So in order to easily understand, remember these police activities, just remember the mnemonic PRA-CIP. P stands for prevention of crime. C stands for crime repression. Then A stands for apprehension of offenders. Then likewise, S stands for search and seizure. I stands for investigation of crime. And P stands for protection of lives and properties. The full context of the powers and duties of the Philippine National Police can be found in Section 24 of Republic Act 6975. You may somehow learn the full context of this once you enrolled the law enforcement administration and organization and administration and police intelligence. So what are the real causes or yes, real root causes of crime? We have first here, if poverty were root cause of crime, then no wealthy people would commit crime. That is according to Mr. Paramahas Hamsa. Most likely it's because actually in the Bible the root causes of crime is because of money. And why those wealthy people, if the root cause is poverty, and why those people who are already rich keep on committing crime? I'm referring to some. I'm not referring to all. Diba? You will hear from the news, millions, billions. They have many assets, and why do they uh, commit crime despite of they are wealthy already? And then the second one, people who have been wealthy in their entire lives may also be frustrated and thus go into drugs. Somehow because of the temptation. Diba? That is how the evil may somehow intervene the lives of a person. Well, of course, if they do not have faith. But why those some of those actors, actresses who engage in illegal drugs, diba? Despite that they are famous, we can say they have assets and they have money, yet they engage in criminal activities like using of drugs or may somehow buying drugs or selling drugs. Next, the most ironic thing about the life of crime is that it is based on a lie, the lie of materialism. They say that they are poor, they say that they don't have any money, but here comes now corruption arises, prevails. It's simply because they want money, they want to have a power. Because they say when you have a lot of money, you become powerful because you can buy whatever you want, you can do whatever you want, okay? You become a powerful. Another is as long as success in life is gauged by the amount of material good amassed, the crime problem cannot be solved. When a person who is greedy of position, um, title, when a person is greedy, becomes already the character of the person, it's hard to be solved. It's hard to be solved. Well, of course, there is a possibility that they will change, but it's hard. Well, of course, not unless if they accepted Jesus as their Lord and Savior. Because things, sudden change will happen when you accepted Jesus as your Lord and Savior. The old has gone, behold, the new has come. And we have here, the last one, the root cause of crime is lack of wisdom in inner satisfaction. They want to be controlled by someone, controlled wherein you are under their custody of committing criminal activities. Likewise, the true wisdom comes from the Lord, not the world. If you put in mind that the wisdom comes from the world, then you have a lack of wisdom. Yes, lack of wisdom. So let us now talk about arrest. Arrest is the lawful taking of a person into custody in order that he may bound to answer for the commission of an offense. As I already mentioned in the first recorded video, what we are talking about here is the lawful taking of a person into custody and not the unlawful taking of a person into custody, because there are two on how will you do the arrest, either lawful or unlawful. Lawful is under the scope of a valid arrest. If it is unlawful, that is prohibited by the law, or it would make the arrest invalid. So I mentioned that the purpose why do we arrest a person is simply because the person committed a crime. We do not arrest by reason of nothing. We arrest, or the police officer is doing arrest because there is a warrant of arrest, or they are pressed by circumstance where they need to perform their obligation when someone committed a crime in their presence, which will fall under the circumstances falling or mentioned under the section 5 of rule 113, which is the warrantless arrest, may arrest the person even without warrant. And what is again the purpose? That is to answer the accusation against him or her. And that would answer the reason why he committed the crime, or if he is the one committed the crime, and if found guilty, will be the judge will impose um, commensurate penalty and even fine if there is prescribed by the law, commensurate to the act committed by the accused. So arrest by virtue of a warrant, it shall be the duty of an officer to whom the warrant of arrest is delivered to the defendant, and without unnecessary delay take the person arrested before the judge or before some other person in authority who issued the warrant as directed therein. Now, once the court or the competent court has established a probable cause to believe that a warrant of arrest must be issued, then the warrant of arrest will be issued to an officer, to an competent officer, it's not civilian, but to a competent officer, and must have to enforce the warrant of arrest without unnecessary delay. Take note of this, without unnecessary delay. And why is it that despite of its validity for within, that it must be served within 10 days? Why does some of wanted person or person to be arrested was just recently arrested after 2 years or 5 years, perhaps? I thought the validity of warrant of arrest is only within 10 days. Later on, I will discuss the lifespan of the warrant of arrest. So, the arrested person must have to be delivered to the proper judicial authority. Okay? So, there are rules in conducting arrest. First, no violence or unnecessary force shall be used in making an arrest. When the situation and similarly situated where there is no need to enforce force, then do it in a peaceful manner. The general rule is you need a protocol that you must have to perform arrest, which it would not violate the rights of the person to be arrested. Remember, all of us have rights and must be protected and must not be abused by the government or even by the state. So when someone is arrested, with violence, force, without the resistance of the person being arrested, the police officer who performed the arrest would be charged administratively or even criminally when the action where or action or his or her action was attended by any other circumstances violating the law. Okay, so when someone is about to be arrested, or when a person is arrested with with unnecessary violence, the person arrested may file a complaint against those police officers, or may somehow by habeas corpus to directly give complaint to the court about his or her arrest, where his rights were violated. Okay, so right then and there, action will be taken. The point here is when you are a police officer, do not enforce arrest by means of unnecessary violence and those other actions that would invalidate arrest and that would violate the rights of the person being arrested. Next is the person arrested shall not be subject to a greater restraint than that necessary for his detention. For example, you are only given less than 12 hours to detain a person, then it must not be violated. Otherwise, you would be violating the law under the revised penal code, pursuant to Article 125, which is the arbitrary detention. So the proper procedure or even the protocol there is you must have to follow all the protocols which would not result to the detention of the person 12 hours and above. Make sure that everything is settled and must be delivered to the proper judicial authority. Otherwise, you might be charged of arbitrary detention. Next is it shall be the duty of the officer executing the warrant of arrest, warrant executing the warrant to arrest the accused and deliver him to the nearest police station or jail without unnecessary delay. So, for example, you are serving the warrant of arrest because any person can enforce the warrant, even just a photocopy. Now, any warrant or any police officer may arrest the person described in the warrant of arrest and must have to be deliver it to the nearest police station. Because like I said, there is hours to be observed when arresting a person under your custody. And it says there without unnecessary delay. But there are some people who were just who were arrested in other country. How about those person to be arrested living in the other country? Well, of course, that would be an exemption. They need to travel. May perhaps it will take them 24 hours or 36 hours. Perhaps that would be, of course, exemption because they cannot control time. They even cannot control the circumstances and even similarly situated circumstances. The point here is when there is a possibility that you can actually deliver him to the nearest police station without unnecessary delay, then it must have to be observed and it must have to be followed. For example, may nakita mo yung taong arestuhin, then do not bring him to your home and have a cup of coffee, or you go to the max because you are hungry and have a merienda for a while. You will eat food before delivering him to the police station. Otherwise, it would invalidate your arrest, or you may somehow violated his rights, because you need the court will must have to know the uh, the situations taken from the beginning at the time that you arrested the person. Okay, so you have to be very careful. Then the head of the office to whom warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from its receipt. From its receipt. The counting will start from the time when you receive the warrant of arrest. Okay, again, the counting will start from the time that you receive the warrant. So within 10 days after its expiration, for example, you were not able to arrested, or the person to be arrested was not yet found, therefore it's not yet arrested, the officer to whom it was assigned for execution shall make a report to the judge who issued the warrant. So ibinigay sa akin yung warrant of arrest. It is not my sole obligation to arrest the person arrested, to be arrested. What will happen is a copy of warrant of arrest will be photocopied and may the assigned, or the yes, the proper authority may cascade a copy of warrant of arrest nationwide. It will be cascaded, so anyone can perform the warrant, but the one who is in charge to report to the competent court the status of the person to be arrested, or a status of the warrant of arrest being executed, shall be the officer whom the warrant was issued by the competent court. Now, for example, what will happen when the police officer did not report after the expiration of the 10 days report? Okay, the or the officer must have to execute a reason, or state the reason why he failed to report within the given time. Okay. Next, an arrest may be made on any day and at any time of the day or night. The warrant of arrest can be executed. Okay, even the warrantless arrest can be executed day and time. Unlike the search warrant, it requires daytime. Exemption if they require to extend their search. Okay? So, if we only arrest person daytime, okay, papasok lang nakatago siya sa during daytime, and during nighttime, saan lang siya lalabas. So now, he is still free to commit crime if that would be the case. Okay, so arrest can be made either at any time of the day or and night. Okay. Then there are requisites of a valid warrant of arrest. It shall be issued upon probable cause. Okay, well, of course, the court will be the one to determine if there is a probable cause that there is necessary to issue a warrant. That probable cause shows that there is really crime committed and there is a person responsible thereof. Of course, we are referring to a human and not an animal. Okay, we cannot arrest an animal, but we can arrest person. In that case, when there is a probable cause where the person to be arrested is the one who is responsible on the crime committed, it shall now be described in the warrant of arrest. If in cases that the person's identity is not definite, or it's not perhaps that person is using different names, addresses, and the like, the warrant of arrest may issue the John Doe warrant. Later on, I will show you. The probable cause is determined personally by the judge upon examination under oath or affirmation of the complainant in the witnesses he may produce. Well, of course, the execution, I mean the issuance of a warrant of arrest would start from the complainant, that there is a complaint, which the court will base on. If, for example, there are also evidence to show that the person, there is a person really committed the crime, and particularly describing the person to be arrested. Okay, so for example, the name, the age, okay, the identity of the person are to be described in the warrant of arrest. But this would be an exemption when the person's identity cannot is not yet determined. So this Jando warrant is issued for the apprehension of a person whose true name is unknown. It satisfies the constitutional right of particularity if the person to be arrested is sufficiently described, which will enable the arresting officer to identify him. Okay. Now, this may have somehow hard for the police officer to find it, but as long as there is a description on the feature of his face, okay, regardless of what name is he is using, as long as what is important is the picture or the feature of the person, so that the executing officer and those police officers may able to identify and um may confident enough that the person to be arrested is the person shown on the picture. Okay? Kung walang picture, mahirap yan. Now, when we say oath, it is only applicable if the person swearing believes in God. They swear to tell the truth, nothing but the whole truth, in the name of God. Well, of course, affirmation is given to those person, applicable if the person does not believe in God. That is why there are two choices. You would either undergo oath or affirmation, hindi pwedeng sabay yan. Okay? Hindi pwedeng mag-oath ka and then mag-affirmation ka. It is either oath or affirmation. And there are methods of arrest by officer by virtue of warrant. First, when making an arrest by virtue of a warrant, the officer shall inform the person to be arrested of the cause of the arrest and of the fact that warrant has been issued for his arrest. Well, of course, the person enforcing the arrest must have to identify himself that he is or she is a police officer who is performing an arrest. Again, it states that you shall inform the person that he is under arrest and must have to inform the person the reason and causes of his or her arrest. Hindi pwedeng inaresto mo na lang without saying word. That may somehow violate his right to know its cause of his arrest. But there is an exemption. What if the person resisted and you're about to inform that you are a police officer, the reason of his or the state, the cause of his arrest, the person to be arrested fled, ran away, tumakbo na siya. So, the police officer may immediately arrest that person and would inform him upon arrest the reason of his arrest and inform and appraise his or her constitutional rights. Okay? So the officer needs to have the warrant in his possession at the time of the arrest, a copy. But there is an exemption when a police officer, while conducting patrol, of course, not all the time you have a copy of warrant of arrest. Incidentally, you saw the person as described in the warrant of arrest, but you do not have a copy of warrant of arrest. Can you still arrest the person? Of course, yes. And upon reaching the police station, must show him the warrant of arrest, the causes of his arrest, and likewise inform his constitutional, his rights. Okay. What are those basic rights? Must have to inform. You must have to inform. You have the right to remain silent. You have the right to remain to have your own counsel. You have the right to have counsel by your own choice. If not, the government will provide you a counsel. Anything you say will be used against you in the court of law. Okay. Now, as a rule, every arrest must be done by virtue of a warrant of arrest. But what are the exemptions to this rule? As is stated in the section 5 of Rule 113 of the Rules of Court, a peace officer or private person may, without warrant, arrest a person. Let us add the examples I already gave to you. Okay, so this is the beauty of recording video recorded, simply because you can still play it anytime you want, any of the day that is convenient to you, and would somehow suffice the explanation of our lecture because I can repeat and expand the discussion. Now, for example, while conducting patrol, I saw someone chasing a person saying magnanakaw. And I saw that person holding bag, a lady bag, and the one chasing him is is a lady. Magnanakaw, magnanakaw. Can I arrest that person without warrant? Of course, yes. Because the person is actually committing a crime and committed the crime. Okay? Actually committing. But the one we are saying that actually committed the crime in your presence when you saw a killing bee. Nakita mo on the spot A is stabbing B. You can arrest the person without warrant. So the first scenario would fall under paragraph A, and the second scenario will fall under paragraph B. Let us read the first paragraph. When in his presence the person to be arrested has committed, is actually committing, or is attempting to commit an offense. So there is the word attempt. Even about to stab, you do not wait for the person that the person or the aggressor or the one or the attacker would able to inflict injury to the victim. Do not wait for that time. You may stop at the moment that the that there is already a situation that will imperil the life of the person being attacked. Let's say, for example, the person is already trying to stab the victim, but the victim was able to evade those attacks. Now, at that moment, you may arrest the person. Do not wait for the person being attacked to uh, to have injury before you may arrest him or arrest the person. Okay? So you must have to take note of that. So even at the moment, because that attempted may also fall under the attempted homicide or maybe grave threat. Okay? Actually, is at the moment that he is trying to stab a person, even without injury inflicted to the victim, the person already committed a law, and that would be somehow grave threat and somehow alarming scandal if it is being was conducted in public. Okay. Another is let me rephrase the example that I already mentioned the previous this which I already mentioned in the recorded video discussion. Meron isang complainant lumapit sa akin saying meron po ako nakita na nagkakaroon ng usapan. One is holding a briefcase and one is holding money. And I see something na mayroon nag-abutan sila. One holding the briefcase is a something has a sachet. The item that is handed to the other person is sachet, plastic rather. And the other person is also handing a money. May perhaps that would be the payment of the item received from the person with the briefcase. So ang ginawa ko, pumunta ako doon sa area. And then when the person showed me where these two persons can be located, okay? Nakita ko sila, inaresto ko. Nakita ko nga, mayroong sachet o shabu dun sa briefcase ng isang tao. And the other person has also a one sachet of shabu. Maybe perhaps that was the item he bought from the person with the briefcase. So the question is the arrest valid? Of course not. Because even though there was really a contraband out there, the method of my arrest is not valid. It would invalidate the arrest reason of my action because it did not based on my personal knowledge. When we say personal knowledge, kita mo, ikaw mismo, it's not knowledge of the other person. It is your own personal knowledge. Though the person telling you has a personal knowledge, you as a police officer has no personal knowledge. It would not bind the personal knowledge of the other person. So, yung personal knowledge, dapat ikaw mismo ang nakakita so that you can enforce the arrest even without warrant. Okay? I thought that is very clear. So, will that be, if that would be the case, hindi valid yung arrest, how about the contrabands? Of course, the Republic Act 9165 prohibits the possession of any kinds of drug. These drugs will not be given back to the rightful owner. Not unless if that item is not prohibited by the law. For example, yung firearm naman is there are documents substantiating and saying na meron siyang license and to carry license. So, kailangan nilang ibalik sa akin. Okay? Because the arrest made is invalid. But if that is the scenario where the items confiscated is prohibited by the law, regardless, even if the arrest made was invalid or not valid, the item still would not be given back to the owner. Okay? So paano ngayon natin ma-arrestuhan mga yan? Of course, you need to apply, you need to secure a warrant of arrest that will make your arrest lawful. Okay? That will make your arrest lawful. Another, yung mga nag-checkpoint, okay, nag-checkpoint. Can they do warrantless arrest? Yes. But remember, yung mga nag-checkpoint, they are not allowed to go inside your car. Yung go inside your car or even try to, yan, butas-butasan yung mga gamit nyo gamit sa loob ng sasakyan. Okay? Ano ngayon ang ginagawa ng dapat ng mga police officers? The plain view doctrine. Pag sinabi natin plain, yung as in plain, tapos view doctrine. Plain, P-L-A-I-N, tapos space V-I-E-W, then doctrine. Plain view doctrine. Ibig sabihin, hanggang sa mata lang sila. Kung ano na lang nakita nila sa loob, okay, yun ang pagbabasyan nila if they will need to arrest the person. Let's say, for example, kitang-kita doon sa salamin kasi hindi siya naman siya masyadong tinted, so kita sa loob. Okay? Merong nakasakay na nakagapos. Okay? And then mayroong tip na mayroong kidnapping na naganap or abduction na nangyari. They can arrest the person or the driver or even the person responsible thereof. Sino yung mga nasa sasakyan. Okay? But let's say, for example, sinabi ko sa driver, buksan mo yung compartment. Or let's say, for example, I open the door, okay, and then search everything inside the car, and I found something, for example, drugs, and arrested the person or the driver. Is the arrest valid? Of course not. Hindi yan yung sinasabi ng plain view doctrine. Plain view doctrine, you are not allowed to do frisking or even searching. What the plain view doctrine stating is it is on the eyes that who can do the viewing, not our hands. Kaya nga plain view, hanggang sa mata lamang. Let's say, for example, you have also the search warrant. Ang nakalagay doon is a firearm. But incidentally, while you are searching, you found something which is drugs. Ang nakalagay doon sa search warrant is 45. Well indicated na yung isi-search nyo. Pero incidentally, during the search, binuksan mo yung cabinet, may nakita kang sachet of shabu, kinuha mo, naresto mo yung may-ari, or kinuha mo, is the confiscation of that drugs valid and you arrested the person? The search and arrest are not valid. Simply because wala ka namang search warrant on the particular item, this sachet of shabu. What has been indicated in the search warrant is the firearm and not the sachet of shabu. Not unless while searching or upon, let's say for example, pagpasok mo or andun ka sa loob na ng kwarto or the room to be searched, may nakita kang protruding or nakapatong or nakasambay or nakalabas na sachet of shabu, okay, you can get that one, you can confiscate that one and use it as an evidence against the person, the owner. Okay, that would not invalidate your confiscation. Okay, yung kanina, kinuha mo, nawala naman dun sa search warrant, tapos hindi pa siya plain view doctrine, magpo-fall siya ng doctrine of fruit of poisonous tree. These are items searched unlawfully, confiscated unlawfully. Magpo-fall na siyang doctrine of fruit of poisonous tree. That would may somehow dismiss the case. Okay? acquittal of the accused by reason of doctrine of fruit of poisonous tree, because the items searched and confiscated are made unlawfully. You can no longer use that as an evidence because the manner how it was confiscated was unlawful. Okay? So going back ito dun sa warrantless arrest, even a citizen can do arrest. That is citizen's arrest in view of these circumstances. Another is when a person is escaped prisoner. Okay, let us read the third paragraph. When the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. Okay? Remember, these are already prisoners. They are already charged. Okay? Both are, dalawa yung tinutukoy dito. One is already who received final judgment and one is temporary confinement who is awaiting trial. And while awaiting trial or while they are transferred to another confinement who are already, kasi kapag na-convict ka na with the final judgment, so you will be transferred to another confinement. For example, sa Muntinlupa. Now, at that moment, you escape or the prisoner or that person escape with final conviction or final judgment or temporary or is awaiting trial, escape. Anybody can arrest that person even without warrant. Okay, even without warrant. Okay. Now, by the way, the warrant of arrest can be served only once only. Can be served once only. Hindi siya pwedeng iserve mo yung warrant of arrest many times. For example, inaresto mo si Alpha and then lumabas, acquitted siya. Tapos iserve mo ulit yung warrant of arrest, same warrant of arrest, same charge against him. Hindi pwede yun. That would violate his right against double jeopardy. Yung double jeopardy, if you are charged with the same offense, with the same circumstances that was already previously dismissed or settled by the court, okay, that is double jeopardy. Now, pero kung sakaling inaresto mo yung maling tao, okay, si A inaresto mo, B pala dapat ang inarestohin mo, but you can still serve the warrant of arrest for B, not for A. Okay? Because the person you have arrested was not the person described in the warrant of arrest. So you can still serve the warrant of arrest to B. Yung sinasabi ko na you cannot serve the warrant of arrest into the same person. Sir, you are not allowed to serve the warrant of arrest twice or more to the same person which was already previously acquitted or where the case was dismissed. Yan yung tinutukoy natin that a warrant of arrest can only be served once only. Once only, ha? Okay. Though it's the validity of the warrant of arrest is tawag noon the lifespan or the validity of the warrant of arrest, what they call na forgot already the term. Okay? Sabihin natin long life. Okay? As long as it was not yet served, the warrant of arrest will still remain and effective. Okay? Kumbaga lifetime yon, lifetime yung validity of the warrant of arrest. Yung binabanggit niya lang na validity is the reporting of the person where the person where the warrant of arrest was issued. Okay, every 13 days, the person who received the warrant of arrest from the competent court will need to report if after 10 days, if the person to be arrested was not yet uh, found and arrested. Now take note, the phrase caught in the act of committing a crime is also known as in flagrante delicto. When we say, you might heard this one in my previous discussion. When you saw a person committing a crime, okay, while committing a crime, or you saw a person committing a crime, that is already caught in the act. When a person was arrested by caught in the act of committing a crime of robbery, okay, so kitang-kita mo caught in the act, which is also known as in flagrante delicto. Which is also known as in flagrante delicto. Okay? So, nakita mo gumagawa siya ng krimen, that is already caught in the act. In flagrante delicto, you arrest in flagrante delicto of the commission or in the commission of crime of robbery, nakita mo siya kung paano niya ginawa. You can arrest the person. Okay? You might heard this term in flagrante delicto. What if a person lawfully arrested escape? Lawfully arrested, can you still arrest that person without warrant? Any person may immediately pursue or retake him without warrant at any time in any place within the Philippines. This is known as hot pursuit, or it may be also be called fresh pursuit. You can still arrest the person, but you must have to stand and you must have to substantiate the reason of arresting him, that the person whom you arrested from the beginning is the person you are arresting, or the arrested person who escaped from lawful arrest is the same person when the time you arrested him yes, from the beginning. Okay, kung sino yung make sure dapat yung inaresto mo ay pare yung taong inaresto mo nung una. Okay? Because the court will determine if the arrest is valid or not. Okay? If you're a police officer, you may somehow arrest that person. It's the court will determine if the if the arrest is valid or not. Okay? Because what you are enforcing is the hot pursuit or the fresh pursuit. Okay? Make sure that you could able to identify, you have the full knowledge of the identity of the person. Kasi pag sinabi mo doon sa korte, na yung kanyang mall or ano pa ba, sabihin natin na yung tattoo niya ay nasa kanan. Pero sa actual, nasa kaliwa pala yung tattoo niya. Lagot. Kasi ibig sabihin, baka maling tao yung nakita mo. Okay? Well, of course, that would be based on the evidence. Testimony. Okay, that will depend which the court may depend as well on the basis of his or her adjudication. Okay, of course, considering all other circumstances that should be considered in giving adjudication. So what are the rights of police officers conducting arrest? First is right to summon assistance. An officer making a lawful arrest may orally summon as many persons as he deems necessary to assist him in effecting the arrest. Depende kung sino yung arrestuhin. Kung isa lang, of course, they need to look, depending kung what would be their strategy. So every person summon by an officer shall assist him in effecting the arrest when he can render such assistance thereto, after announcing his authority and purpose. Okay? Pwede kang magsama ng kasamaan mo depending what your chief of police had given or the instruction given by the chief of police. Then, right to break into building or enclosure. An officer, in order to make an arrest either by virtue of warrant or without warrant, may break into any building or enclosure where the person to be arrested is or is reasonably believed to be. If he refuse admittance, remember, if he refuse admittance, or he doesn't want people to get in, or no one is answering inside the building despite of his presence, after announcing his authority, his or her authority and purpose. Everything have already settled. Everything is already settled. You have already mentioned your purpose, your identity, everything. But yet you do not want to open the door, the locked door, yet there is a person inside. They know that there is a person inside, and the person to be arrested is in that building or in that enclosure. Okay, they can break it, of course, by means that are accepted. Hindi yung grenade para makakaroon. Hindi yung sabugan mo ng granada upang magkaroon ng butas kung saan ka makakapasok. Of course, that is unnecessary means of breaking into a building or enclosure. Next is the right to break out from building or enclosure. Whenever an officer has entered a building or enclosure to conduct arrest, he may break out therefrom when necessary to liberate himself. Okay? When necessary, for example, naresto mo yung isang tao, tapos ang dami palang kasama nung narestong tao, well, of course, you can no longer use the door. You may use other points of exit, or you may also find ways to have a way to get out from that building or enclosure if you are already in danger, or if there is really necessary. Again, there is necessary. Pero yung mga necessary, hindi pwede, hindi ka tanggap-tanggap doon. Of course, kapag nangyari yon, there might be somehow, it will not give effect to the, it will not give total effect naman doon sa arrest of the person, but somehow the police officer may be charged administratively or criminally if there are some other laws violated. So what are the rights of the arrested persons? Okay, so the rights of arrested persons should be followed, that must be followed by the police officer, is the right against torture, intimidation, and other related rights. And right to be visited and conferred privately with his lawyer in the jail or any other place of custody at any hour of the day or night, subject to reasonable regulations. Okay, you will somehow learn this when you enroll the specialized crime investigation. Okay, one, and then the second one is when you learn also the special penal law, and the rest are in the books, book criminal law subjects. So what are the crimes that may be committed by a police officer while conducting patrol, whether with or without warrant? Okay, when these are made unlawfully and the result is the violation of law, you may somehow, these are the following, or these are the examples: delay in the delivery of arrested persons to the proper judicial authority. Now, this article, this is found in Article 125 of the Revised Penal Code, Book 2. Delay in delivery of detained persons to the proper judicial authorities. Okay, so this is only applicable to public officer or employee who shall detain any person for some legal ground and fail to deliver such person to the proper judicial authorities within the period. What is that? 12-18-36. Of course, yung pinakamababa is the 12. Okay, by light penalties. Okay, yung 18 naman is for crimes or offenses punishable by correctional penalties. And 36 example, 36 hours for crimes or offenses punishable by afflictive or capital offenses, capital penalties or their equivalent. I'll give you an example. A police arrested a person for the crime of rape, which is punishable by an afflictive penalty. Yan na yung reclusion perpetua. In such case, the arrested person must be charged before the court with the crime of rape within 36 hours from arrest. Otherwise, the arrested officer is liable for arbitrary detention. Okay, arbitrary detention. So, kailangan nga yung oras na depending on the crime. Of course, there is an exemption. Exemption, yung sinabi ko na ay yung narestong tao ay nasa ibang bansa. Okay? That it requires them more than 36 hours to travel to head back here in the Philippines. Next is the unlawful arrest, which is the Article 269 or the RPC. It is committed by any person who, in any case, other than those authorized by law, shall arrest or detain another for the purpose of delivering him to proper judicial authorities. Bigyan ko kayo ng example. Itong si police officer, nakakita siya ng suspicious lang naman but without reasonable cause. He arrested the person and brought it into their station, filed a criminal case even without evidence, or he knows that there is no evidence to substantiate his claim of charging certain crime. Walang ebidensya, kinasuhan mo ako ako yung inaresto mo. Kinasuhan mo ako ng krimeng pagpasa, wala namang ebidensya. That person is liable of unlawful arrest. That is under Article 269 of the Revised Penal Code. Okay. Next is the, by the way, what if the arrest is authorized and the person arrested is any other place from jail or police station? Ang ginawa niya is authorized siya to do the arrest. However, ang ginawa niya is instead of delivering him or her, depending what would be the succeeding circumstances that would happen. Now, take note, if the arresting person detains the arrested person without legal ground, he is liable either, okay, illegal detention if the detaining person is a private person, or the one who arrested the person and detained the person arrested is a private person. For example, I'm a private person. Inaresto ko ng isang tao. And then without any legal grounds, I might be charged of illegal detention. Pero a police officer without legal grounds, okay, arrested a person, that would be arbitrary detention. Okay? The person liable here is a public officer under ng arbitrary detention. Doon naman sa Article 1 to 5, there is a legal ground. However, that would make a person violate this article is when the police officer failed to comply with the corresponding hours given, okay, given by the law. Pero kapag, for example, naresto mo ko without any legal grounds, that will be arbitrary detention. Now, what if the arrest is authorized? It's not authorized by law and with lewd design. With lewd design. Pag sinabi natin lewd design, there is lewd design when the person has the intention to have a sexual intercourse with the arrested person. Okay? So, what if the arrest is not authorized by law and with lewd design? The arresting person committed the crime of forcible abduction. Forcible abduction. Pero kapag renape niya, well, of course, that would be another case. You might be, the person might be charged of Republic Act 8353, which is rape. Okay? Next is the expulsion. It is committed by any public officer or employee who, not being authorized by law, again, not authorized by law, shall expel any person from the Philippine Islands or shall compel such person to change his residence. I'll give you an example. A policeman arrested a person at Bacoor, Cavite, and delivered the arrested person to Manila, directing the latter that it is better if he is going to reside at Manila. For example, taga Bacoor ako. Tapos someone arrested me and asked me and delivered me to Manila and changed my residence. Okay, that is expulsion. That is expulsion. So next is what is search. Okay, I'm not referring to what we usually do to search on the internet. Okay, what is a search warrant? Search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directing to a peace officer, commanding him to search for personal property, describing therein, and bring it before the court. You can find this in section 1, rule 126 of the rules of the court. So, when we say search warrant, it is the item, not the person. If we are finding a person and arresting a person, that is under warrant of arrest. But if we are finding the place and the item to be searched, that is search warrant. So search warrant is applicable for item, property, while the warrant of arrest is applicable for person. So what are the requisites of a valid search warrant? To become valid, it shall be issued upon probable cause, same as the warrant of arrest. Probable cause to believe that the item to be searched is prohibited by the law. Likewise, there is a need that that the items that must be searched and must be found in order to substantiate the um, case to be filed or the filed case. The probable cause is determined personally by the judge upon examination under oath, again, under oath or affirmation of the complainant and the witnesses he may produce. A and B have the same requisites with the warrant of arrest. That makes them different is the third requisite. The third requisite for valid for search warrant is particularly describing the things and the place to be searched. You can find also this one in section 2, article 3 of the Philippine Constitution. Okay, so we are um kumbaga treasure hunter ito eh. You will need to know the place for you to know where you can find the item to be searched. So, what are the subjects of a search warrant? A search warrant may be issued for the search and seizure of the following personal properties, subject of the offense. Perhaps it was used in the commission of a crime. Let's say, for example, the firearm was used in the commission of crime. The firearm was stored or uh, hidden in the house of the perpetrator. So to find that, because without the search warrant, the police officers may not able to enter uh, others' dwelling or the other house. So to make it valid, they must have to carry or arm with search warrant. And then the stolen or embezzled in other proceeds or fruits of the offense. Let's say for example, yung stolen items. Let's say for example, ninakaw nila yung aking mga kagamitan and they cannot find it, only to find out na inilagay nila sa kanilang stock room. So in order to get that one and um, to get those items and subject uh, for the what do you call uh, to substantiate the evidence and to give justice to what happened to me, they need to have a search warrant. And once found out that the the items stolen from me are found in the house of B, and then those can be used as an evidence against the person who stole the items. And proceeds fruits of the offense, like it has something to do with letter A, which was used, or let's say for example, is exchange of firearm, for example, nagkakaroon ng mga transaction, palitan ng mga armas, which are, of course, violation of the law of the land. Okay, so this should be as well be searched and be confiscated. Then used or intended to be used as a means if committing a crime. For example, yung mga computer natin was used in the commission of a cybercrime, those computers may as well need to be searched, confiscated uh, while doing the investigation, but requires search warrant. So remember, real property and personal property. Okay, real property are those property that cannot be moved or cannot be carried out, while personal property that are these are property that are movable. Okay, so there is a need for policemen to be armed with search warrant when conducting search, unlike when conducting arrest. Kasi yung search warrant, you must have always a copy of search warrant. Okay, while the warrant of arrest, incidentally, while conducting patrol use of the person described in the warrant of arrest, you can arrest that person even without the warrant of arrest with you during the time of arrest. But you must have to show it once you are in the police station. The copy of warrant of arrest. Dito, search warrant, before you may be allowed to enter or you can go enter the house of another or rooms of another, you must have a copy or you must be armed with search warrant. So, when to serve a search warrant? The search warrant must direct that it be served in the daytime. Okay? Unlike sa warrant of arrest, day and night. Ito, daytime lang. But there is an exemption. What is that exemption? Of course, when it requires let's say for example, 5 o'clock. Ngayon, you need to go beyond 5 o'clock in the afternoon to before. Okay? Things will happen. For example, bago dumarating ang hindi inaasahan. Let's say for example, typhoon. Okay? So unless the affidavit asserts that the property is on the person or on the place ordered to be searched, in which case a direction may be inserted that it be served at any time of the day or night. For example, nasa nasa tao yung items na hinahanap nila. Then kailangan nilang hanapin yung tao at kunin lamang yung items, but that person cannot be arrested. At unless you have a copy also of warrant of arrest. But if you have the warrant of arrest and a search warrant, of course, you can both serve this warrant. Okay, so you can arrest that person hiding the items to be searched. Okay, you can enforce these two warrants. The question here is, what is the lifespan of search warrant? A search warrant shall be valid within 10 days from its date. Within 10 days. Kung anong nakalagay na date, doon mag-start yung counting. Yung warrant of arrest upon receipt. That is the counting. Upon receipt of the warrant of arrest. Ito naman is the date stated. Let's say for example, what's the date today? October 28, then magka-count siya. It will start it from its date. Okay, thereafter, it shall not become void. Okay, kung hindi na nila na-serve within that 10 days, they must have to secure another search warrant. It would not be the same search warrant. They must have to apply or they must secure again application for the search warrant. Okay? Otherwise, it will become void already. Pag lumampas na yung 10 days, hindi na pwede. Okay? Hindi na siya pwede. So, to know exactly the difference between these two, okay? Again, this is an overview of the warrant of arrest and search warrant. You will soon discuss thoroughly and it will be expanded in the discussion once you have these rules of court. Okay? So the distinction between the warrant of arrest and search warrant are the following here. First, the warrant of arrest and search warrant are orders in writing issued in the name of the people of the Philippines. Diyan yung magkakapareho sila. Let us find first the similarity. Signed by a judge and directed to a peace officer. Dalawa sila ganyan. Again, the warrant of arrest and search warrant are orders in writing issued in the name of the people of the Philippines. Hindi siya pwedeng verbal. They are reduced into writing. And signed by the judge because the judge who personally examined the probable cause and likewise has the competent to issue a warrant and directed to a peace officer. That peace officer is the one who is responsible giving the report of the execution of the warrant. The warrant of arrest and search warrants are issued only upon probable cause. Upon probable cause. Di ba? Nabanggit na natin na yung magkapareho sila. Now, ito lang yung pagkakaiba nila. Di ba sa third requisite? The warrant of arrest is intended to arrest the person described in the warrant of arrest while a search warrant is intended to search and seize things specified therein. The warrant of arrest remains valid as long as the person stated therein is not yet arrested, regardless of the number of days that already lapsed. Basta after 10 days, the person or the peace officer must have to report to the competent court who issued the warrant the reason of why the person was not yet arrested. While the search warrant is valid within 10 days from issue only. Then the warrant of arrest may not be in possession of the arresting person when conducting arrest but must be shown once the person arrested is in the nearest police station and appraise its constitutional rights. While search warrant, the peace officer must have with him and arm with him with the search warrant before he can do search and seizure. Then the warrant of arrest may be executed any time of the day and night, while search warrant, as a rule, must be executed during daytime, not unless the item to be searched is carried by the person or the circumstances require them to extend. Well, of course, that will be exemption. However, the peace officer must have to state in the affidavit the reason of why they conducted or the modes of their search and seizure fall during nighttime. Okay? Now, what is the rule in conducting search and seizure? Doon sa consented search, under the consented search, the right against unreasonable search and seizure may be voluntarily waived by a person being searched provided the following are present. Yung existence of a right. After you have already mentioned of its rights and he knows his rights. And he has knowledge. He understood, she understood his right or her right. And said person had actual intention of relinquishing such right. Kumbaga, wini-waive niya and has the capacity to waive his right or her right. That makes a person or peace officer may allowed to search the area. Okay? When these three are present. Otherwise, hindi siya pwedeng makapasok. Next is the search incidental to lawful arrest. Well, of course, during the execution of warrant of arrest or warrantless arrest, or the arrest was arrested either warrant of arrest or warrantless arrest, you can freeze the person and find if there are any weapons, or it happens na during the frisking ay may nakita kang sachet of shabu, pwede yon. Pwede mong gamitin. You can use of those evidence, use those items against as an evidence against him. So under search and incidental to lawful arrest, a person lawfully arrested may be searched for dangerous weapons kasi hindi mo nga alam baka mamaya during the arrest meron siyang tinatagong mga armas, ikaw pa ang matudas. Diba? So upon arrest, you need to frisk the person, search any contrabands or prohibited items. Okay? So you may also find there the evidence that may proof or have been used or constitute proof in the commission of an offense without a search warrant. Still under ito ng Section 13 of Rule 126 of the Rules of Court. Then by plain view search or the plain view doctrine, illegal things at sight may be seized even without a warrant to do so. The things must be readily seen without any effort of locating it. Without any effort, yung mata lang na pwedeng tumingin ang nakakita. Okay? Pero hindi mo lang tititigan. Okay? You don't have the what you call the power to make things move. Magbukas ka cabinet kasi mata lang pwedeng pwedeng makakita. Okay. Gaya ng sabi ko, kahit na may sachet of shabu, pero you have made an effort to search and was incidentally nagpakita, hindi siya pwedeng magamit as evidence against the person. It will fall under the doctrine of fruit of poisonous tree. Fruit of poisonous tree. Okay? Ito yung mga poisonous na fruit. na prutas na galing sa puno. Okay? So, hanggang sa tingin lamang. Kaya yung mga napapanood nyo doon sa Facebook, yung silang nagbubukas doon sa compartment ng motor, bawal yun. Bawal yun. Not unless they have the search warrant. Kaya yung mga nag-checkpoint hanggang sa tingin lamang. Okay? Next is search in moving vehicle or checkpoint. Ito yon. A search made in the checkpoints shall be limited to visual search. Yan, visual search lamang. And neither the vehicle nor the occupant shall be subjected to physical search or require the passenger to alight from the vehicle. If the police officer asks you to alight or to get up or move out from that vehicle and ask you to stop there for them to frisk you, that is prohibited and not accepted, and you may refuse, okay, to be frisked. So an extensive search may be allowed only if the officers conducting search have probable cause to believe that they would find evidence pertaining to the commission of the crime in the vehicle to be searched and there is no sufficient time to secure a valid warrant upon which the passengers shall be required to alight from the vehicle to effect the search. For example, may mga duguan. Why there are protruding, okay, protruding something, the armaments, yung mga weapon, high-powered guns. Ayun, pwede nilang they have the reasonable cause to search the engine. Search the vehicle. Diba? And then, when we say custom search, under custom search, the personnel of Bureau of Customs conduct search to enforce customs law or to regulate exports and imports. Yung mga bagahe na ini-import natin or ini-export dito sa Pilipinas, they have the right to search. They can make use of the what we call thermal imaging scanner. But of course, they're prohibited also to open but then if there is suspicion, okay, something local dun sa documents, may depending if there is a required or necessary to search the box or the yung mga bagahe, then it may be done, okay, in a rightful manner. Rightful manner. Okay? So, sir, bakit mga ganun nang baka mapapansin nyo that you have someone said, okay, maybe in the defense mechanism of the other party, while some police officer just went into the house of another, and here comes to us now a firearm, wala naman talaga. Well, of course, I cannot answer that. Okay, because I do not know exactly what happened, and I do not have any basis or evidence to prove or even to answer this statement. Okay? Next, crimes that may be committed by a policeman while conducting search. For example, violation of domicile. Ito yung pwede kung wala kang search warrant, tapos nagpilitan mo pumunta ka ng bahay nila para mag-search, maghalugpog. Okay, you might be charged of violation of domicile. Kapag sa private, it is trespassing to dwelling. Pero ang public officer ang offender, that is violation of domicile. Okay? So, violation of domicile is committed by any public officer or employee who, not being authorized by judicial order, shall enter the dwelling against the will of the owner. Search papers or other effects found therein without the previous consent of the owner, or having surreptitiously entered said dwelling and being required to leave said premises, shall refuse to do so. Pumilit siyang pumasok and then palabasin mo, ayaw niya. And all the evidence that may be found in your house and use it for as an evidence against you cannot be, okay, accepted. It will not become admissible as evidence. It will fall under because of its unlawful search and seizure of those items. Another is search warrant maliciously obtained. Search warrant obtained is committed by a public officer or employee. Ito lang ang titignan natin, public officer or employee who procures a search warrant without just cause. Wala namang dahilan eh. Diba? So, you will learn this. That is under Article 129 of the Revised Penal Code. Next is abuse in the authority of search warrants legally obtained. Okay? Abuse. Okay? It is committed by a public officer or employee who has legally procured a search warrant. However, he exceeds the authority of the search warrant or he uses unnecessary severity in executing the same. Let's say, for example, okay, meron na siyang search warrant, tapos pagpasok niya sa bahay, but ginulo-gulo na yung mga gamit nyo doon, basag yung mga gamit nyo. Okay, that is already abuse in the authority. So, pwede siyang ma-charge under Article 130 of the, Article 129 of the Revised Penal Code Book 2. Yung pang-apat naman, searching domicile without witnesses, hindi pwede kasi yon na walang tao. Kanino mo pinaalam kung walang tao, di ba? Okay? Hindi ka naman pwedeng, sir, ma'am, you are talking a ghost perhaps. I have a copy of search warrant and the cause of this search warrant is blah, blah, blah right then and there. Okay. Kinausap mo hangin. Hindi pwede yun. So, searching domicile without witnesses is committed by a public officer or employee who is armed with search warrant legally. Legal naman meron siyang search warrant. However, without it was being effected and enforced without the presence of the owner or any member of the family, or at least yung two witnesses rule residing in the same locality. If that you search the area without these requisites, you will be charged under Article 130 of the Revised Penal Code Book 2. Okay. Now, let us move on to the discretion. Discretion is the wise use of one's judgment, personal experience, and common sense to decide a particular situation. Now, when we say discretion, yung kailangan natin yung wisdom. Yes, we have the authority to decide, but at least it must be in a right prudent, in the right manner, in the right time. It is wise use of judgment. That is the wisdom. Okay? So, police officers are decision makers and most of their decisions are based on discretion. Kaya yung tinatawag natin police discretion na rin. But everyone has its discretion. But depending on how you use it, okay, is your decision correct, wise, legitimate, accepted? Okay. So one of the most numerous situations encountered by the police in their daily enforcement rule is, okay, when they somehow shoot the person being chased. Okay, let's say for example, kill him. Okay, which is not necessarily, which is not necessarily. Again, these are making some decision that are not necessarily that would in what they call impair the other's right. Let's say, for example, if your decision violates the right of the other person or injures, yes, violates the rights of other person, where wherein the decision made is unnecessary. Which supposedly you can make some decision that is appropriately and lawfully and acceptably. Okay? So, discretion requires the when you have a good decision or discretion, you would have a good effect or even the outcome. Kasi when you made a wrong decision, you might be somehow you might be charged administratively or criminally. Okay. There was this case, the people of the Philippines versus Uwanis. Okay, there was this order to kill the person who is suspected na terrorist. So, in that room, so ang ginawa ng mga subordinates, pumasok sila sa room, yan, pinagbabaril na yung nakahiga. Without knowing, iba pala yung nakahiga. So, Juanes was charged and convicted. Diba? Because supposedly, they have time to verify, nakatulog na nga eh. They can verify if the person whom they will kill it or to shoot it is the person described. Nangyari hindi eh. So, the wrong decision. So, what happened? Convicted. Convicted. Now, there is the control discretion. Chief Justice of the Supreme Court, Warren E. Berger, has quoted, "No lawyer, no law book, no judge can readily tell the policeman on the beat how to exercise his discretion perfectly in every of the thousands of different situations that can arise in the R work of a policeman." Okay? Ganito lang kasi yon. Sometimes we do not have experience and we have to rely it on books or even other experiences. Kaya nga we cannot say that this is a theory because these were actually happen in the previous. Kaya nga yung bakit yung mga previous decisions by the Supreme Court can be as well if it's still similarly it is same case, same decision making pa rin ang gagawin nila. So those previous mistakes actually become the basis of your discretion as well. Okay? So you must have to recognize that we need not choose between no guidelines at all or effect guidelines at all and perfect guideline. There must be some guidance by way of basic concepts that will assist the officer in these circumstances. Diba? Without the book, without yung mga standards, procedures. Kaya nga hindi pwede yung sabihin niya, theory lang mga yun, iba na pag nasa situation. What? Let's say for example, in your capacity, I ask you to explain how the firearm be operated. Oh, Diba? Alam mo lang gamitin pero hindi mo alam kung paano yung mechanism ng firearm that will suffice you. What if even you are in the court? I'm so sorry. I know only how to use firearm but I do not know the mechanism. Kaya nagkakaroon ng acquittal or dismissal of the case by reason of lack of knowledge, by reason that they do not conform to the protocols, they do not conform with the principles, they do not conform to the laws, principles of laws. Diba? Ay yung by the book naman talaga yung law, diba? If you cannot follow it, you might be charged or the case may be dismissed or the accused may be acquitted. So the discretion here may be based it on the experience, others' experience, or actually. So the basis of your discretion also, okay, you need basic concepts. Ano yung dapat? Kaya nagkakaroon na ng training of leadership, di ba? To come up with good decision making. Discretion is a matter of common sense and sound judgment. And yet we know the one man's common sense may be another's mistake. Hence, this need for careful device basic methods or standards to guide the exercise of this discretion, and second, for care and comprehensive training of officer before they are thrust into situations that would even battle the wisest judge. Kaya nga lahat naman pinag-aaralan natin. Me, I'm the head of the college. It requires discretion. So I need also to learn, I need to read, I need to know those laws or even guidelines surrounding the college or the university. That will now become my basis of discretion. That kung I will be invited soon to become your lecturer on the decision making, I can show you and discuss you how to come up with a good decision making. Okay, that is under ng CFLM 1. CFLM 2, Character Formation, Leadership, Administration, and Decision Making. Now, if you have a wrong decision making, okay, ang kalalabasan niyan is either you impaired or even prejudice to the other party. Yan yung mga causes na. Kaya nga ba pag minsan, because of poor decision making, baril ka ng baril. Okay. Tawag dito, nag-warning shot ka sa public. Okay, I need to follow warning shot before I can shoot you. Nag-warning shot ka sa public sa maraming tao. Siyempre, the projectile, once it reach its accuracy, will form a parabolic arc, and what will happen? The projectile may fall down and will land perhaps dun sa building, sa mga tao, may nagbatay pa. Innocent pa yan. Do you think you made a good decision making? Oh. What else more yung other mga poor decision making? Ayun, mga napapanood natin na recently, yung mga pumatak sa ating isipan, a police officer who killed yung mag-ina ata yun. Okay? The other one, talagang grabe, kitang-kita how they killed the victim. Because decision making must not controlled by emotion. Must not be controlled by emotion, ha? If you are anger and you are being controlled by emotion, hindi pwede yan. Hindi pwede. Even in the biblical principle. Do not let emotions control us. Okay? So discretion requires actually with good mind. So, sets of mind. Okay? So, we have the discretion to decide good or evil. But the point, the scope of our discussion here is must be the good discretion, the good decision making. Let's say, for example, the situation shows, okay, you are a patrol officer, or you are a police officer conducting patrol. Now, someone is threatening you. Sabi, sabi niya sa'yo, hey, police officer, I will kill you by verbal. And what you have done, my life is already a threat and in danger. Ginawa mo, binunot mo yung firearm mo, bang! Do you think you made a justifiable defense? Of course not. That is not a self-defense. Because the means of killing the person is unnecessary. You are not at danger. Hindi mo na-meet yung requisites na kailangan ng Article 11 of RPC, which is the justifying circumstances. Mali, you know. Okay? You are not exempted. Di ba? So, kailangan pa rin tayong mga ganito mga batas, yung mga requisites. And kailangan natin mag-aral, mag-training, and so on. So, that is it. Kailangan yung true discretion. So, doon sa exam nyo, I might going to play situation na what are you going to do? Let us test your decision making. Your decision making, ha? Tingnan natin. Then, what is custodial investigation? Is any questioning initiated by law enforcement officers after a person has been taken into custody of otherwise deprived of his freedom of action in any significant way. So, yung custodial investigation, okay? For a person arrested, or actually, when a person is already invited to go in their office for investigation, you are already under custodial investigation, not necessarily that you were arrested. Once you are invited and you are investigated, you are under the custodial investigation. That is the questioning initiated by the law enforcement officers. It is related to the case they are investigating. Okay? However, dun sa mga arrested, of course, it requires yung requisites. The questions being asked are no longer general inquiry. And the person being questioned is considered as a suspect in the crime committed. So, they will be temporarily confined. They are temporarily confined. Yan yung mga custodial investigations. So, what are those examples that are being implied? Let's, for example, what is your complete name? How young are you? Are you still single? Yung mga information of your occupation. And then, right then and there, after they have the evidence, they can also ask if it is true that they are the one who committed the crime. If they refuse to tell the truth, it so be it. It's the court to determine whether or not the person is guilty. And there are tools of criminal investigation: information, interview, and instrumentation. This will also again discuss in your criminology 1. So these are 3 I's. Just remember yung 3 I's. Information defined as the knowledge which the investigator gathered and acquired from a source. For example, meron tayong primary source. It could be in his personal knowledge, and the other source, it would be from the testimony of the witnesses. And other informations are also still under this I of criminal investigation. And then interrogation is a questioning of a person suspected of having committed an offense who is reluctant to make a full disclosure formation in his possession which is pertinent to the investigation. Okay? Then let me later on discuss the distinction between these two. Okay? Yung interrogation and interview. Pero kuan muna tayo sa interview. The questioning of a person who is believed to possess knowledge that is official interest to the investigator. Kung sino yung nakakita ng krimen. And while instrumentation, these are the um, application of instruments and methods of physical science to the detection of crime. What are those other means to identify the determination of what really happened? For example, we can make use of the forensics, like ballistics, like the question document examination, and other forensics that may be considered for your investigation to substantiate or to help you to identify and to determine what really happened and to know what factually happened. Okay, so information, interview, and instrumentation. Ito yung instrumentation. Ano yung mga gamit na pwede nyo gamitin for your investigation? Okay? For example, also yung you have this computer to retrieve those files. So anong pinagkaiba nito? What is the difference between interview and interrogation? Anong pinagkaiba nitong dalawa? So sa interview, the person being interviewed here, being asked here is a witness who saw the crime. While interrogation, the person being asked here is the suspect, which is directly asked or being asked connected and relevant to the case under investigation. Ganun lang pinagkaiba sa interview. The one that the person being interviewed here is the witness or the witnesses, while interrogation, the person being asked here is the or are the suspects. Okay? So sa interrogation, sa interview is we are referring to the knowledge of the witness who possessed such information or possess such knowledge about what happened. Okay, that will really help to reveal what happened. Well, sa interrogation is pwede na rin doon sa mga taong ay yung witnesses who do not want, perhaps, who do not want to cooperate or those who are reluctant. Pwede siyang witness na kasama na rin. Okay, pwede siyang accessory or yes, accessory of the crime. Yan, pwede na rin siya. Kasi yung mga reluctant, itong mga interview, these are witnesses who are willing to divulge information based on their personal knowledge. Okay, further discuss about the custodian investigation. Yung place of inquiry, sinabi natin place or general inquiry, we are referring to question that may be asked to any person. Okay? Yung sinabi ko, what is your name? How young are you? Yung mga general inquiry. So in case of homicide, a policeman in interviewing a person to determine if that person can identify the suspect, is there custodial investigation in this case? Again, in a case of homicide, a policeman is interviewing a person to determine if that person can identify the suspect. Is there custodial investigation in this case? The answer is none yet. There is no custodial investigation in this case because the person being investigated is not yet considered as a suspect in the crime of committed. It is just only siguro verification. This even if in truth the person being investigated is the one who committed the crime. Okay, it was only a general verification perhaps. So what if a person is already, okay, ayos natin yung camera natin para nag-blur data. Tayo. Now, what if a person is already considered as a suspect, so he is being investigated inside his house, is inside his own house, and the purpose of said investigation is to determine his participation in the crime committed. Is there custodial investigation? Again, what if a person is already considered as a suspect? So he is being investigated inside his own house, and the purpose of said investigation is to determine his participation in the crime committed. Is there a custodial investigation? The answer is yes. There is custodial investigation. This is because the determining factor in the existence of custodial investigation is whether or not the requisites of custodial investigation are present. Ano mga requisites? Ano yung mga requisites again? The questions being asked are no longer general inquiry. And the person being questioned is considered as a suspect in the crime committed. Though a part of the custodial investigation is knowing his name, young, his age, status, but when there are already the subsisting questions or subsequent questions are related to the case under investigation, it will now fall under custodial investigation. It is no longer general inquiry. Okay? So, the place of conducting investigation is not a determining factor, regardless. The point here, as long as the two requisites under custodial investigations are present, you are now under their custody on investigation. I'm now in the new room. Okay. So let us talk about what are the rights of a person under custodial investigation, which I already mentioned some part of it. So first is the right to be informed of his right to remain silent. You have the right to remain silent. And right to have a competent and independent counsel, preferably of his own choice or to be provided with one. For example, walang-wala ka talaga, wala kang pera to, you don't have you cannot afford to have a counsel of your own choice. Okay, the court can provide you one. Yan yung mga galing na dun sa public attorney's office. Then, right against torture, force, violence, threat, and intimidation or any other means which visits his free will. For example, you are being intimidated, you are forced, tortured just to say something or may somehow confess. Bawal yon. Though kapag nangyari man ganon, ikaw ba ang pumatay kay si Rizal, mapapaamin ka talaga sa sakit ng bugbog nila sa iyo. Okay? So they cannot still make use of that statements against you because those are extra judicial confession which was made by means of force. Hindi siya pwede. Okay? Hindi siya pwede. And then, tinakot ka, mga ganun, hindi rin pwede. Kahit na natakot ka, nagbigay ka ng statement or testimonya, they cannot use that as an evidence against you. Even they stated that you confessed, hindi pwede. Kaya nga, ginagawa nila ngayon, it must be recorded, videoed, that all are set with the presence of the counsel, that you really made an extrajudicial confession, ayan, which is substantiated with corpus delicti, pwede yon, tanggap-tanggap. So, then another right is right not to be held in secret, solitary, incommunicado, yung mga solitary confinement na kayo-kayo lamang. Dapat you have you must be accompanied with counsel every time they will take statement from you. And any other similar forms of detention because that will violates your rights. Okay? Lalo na doon sa Section 12 Article sa Philippine Constitution. Okay. So meron po bang waiver doon sa custodial waiver that we can waive? Are there any requisites needed to waive its rights? Okay. So the person, okay, the person under investigation for the commission of an offense shall have the right to waive his right to remain silent and the right to have a counsel provided that the following must be present. Kasi meron siyan I'm not I'm not endorsing yung si late President Ferdinand Marcos who did not or waive his right to have his own counsel because he's now already the counsel of himself. Okay, so here are the requisites before a right can be waived. The waiver is done voluntarily and the person making a waiver has the capacity to do the waiver. Done intelligently, Okay? Dapat rationally, you understood everything and even the consequences, everything you understood. And in the presence of a competent and independent counsel. And it must be reduced into writing. And take note ha, the enumerated rights are known as Miranda rights. Yan yung ina-appraise natin. Miranda rights or constitutional rights of a person under investigation for the commission of the offense. The word Miranda came from the name of Ernesto Miranda, who was the accused in the prominent case entitled Miranda versus Arizona. Kaya meron na yung Miranda rights. It must be informed kasi during the arrest, dapat alam niya kung ano yung gagawin niya and must know the arrest. Tanong dito is, paano kapag yung Miranda rights was not complied or appraisal of the constitutional right was not complied? Okay. Was not complied by the investigating officer. What will happen then now? Okay? Anong mangyayari dyan? Will that invalidate the arrest? Now, if the rights stated in the proceeding questions are not complied by the investigating officer, any admission, confession, or any other evidence obtained during the investigation is inadmissible in any proceedings. Kasama niya yan, mawawala na. Because it must be appraised. The Miranda rights of the arrested person must be appraised first. Yan yung unang-una. Kaya during the, while at the time while you are arresting a officer, you can appraise the constitutional rights, Miranda rights. You have the right to remain silent. Sabihin mo na. And then you will again, once arrested, once you brought him in the station, you must again appraise his or her constitutional rights. Kailan? Okay? Of course, kung no read no write yung inaresto mo, then you have to say it into language that is known to him. Well, of course, those terms that are used for translation. Let's say, for example, mayroon kang karapatang manahimik. You have the right to remain silent. Okay? Hindi yung mga translation na hindi naman akma sa um, mandated constitutional rights. And then, this is known as the doctrine of fruit of poisonous tree if that would be happen. You arrested a person without appraising the constitutional rights. Okay? This is a doctrine of fruit of poisonous tree. So, this doctrine states, itong doctrine na to, itong fruit of poisonous tree, states that any evidence illegally obtained is not admissible in any proceeding. Kaya nga pati yung mga evidence na na-search mo na hindi naman nakalagay sa search warrant, tapos kinuha mo and use it as an evidence, that is already inadmissible. Okay? Will fall under the doctrine of fruit of poisonous tree. So in addition to the non-admissibility of the evidence obtained, the investigating policeman may also be charged criminally. Hindi lang yan. Administratively, halos magkasama yan eh. Okay? Or even civilly. Kailangan mo magbayad. Okay? For any damages incurred caused by your action. Now, paano naman pag ganito? If the investigating official is not a policeman, is there a need for him to state the rights of a person under investigation for the commission of an offense? Diba nagpapanood natin sa pelikula? Kung ayaw ng police officers to conduct investigation, I myself will conduct the investigation. Should I have to state his rights? Okay. There is no need to state the rights of the person under investigation. For example na lang yung citizen's arrest. Okay? You're not a public officer or employee. Okay? So if you yourself is a private and you enforce citizen's arrest, there is no need to state the rights of persons under investigation for the commission of the offense. These rights are being informed. Yung mga rights na Miranda rights or constitutional rights are only being informed by the investigating officer of a law enforcement agency. Okay? Now, to give you some difference between itong admission versus confession. Okay? Yung confession is direct acknowledgement of guilt, while admission is indirect acknowledgement of guilt. I will give you an illustration. Yung acknowledgement acknowledgement walang E. Okay, walang E doon ha. ACKNOWLEDGMENT. Acknowledgement. Okay? Confession is direct acknowledgement of guilt, while admission is indirect acknowledgement of guilt. Let me give you an illustration on this. Okay, dito lang rationally. Sa rules of sa evidence, you will discuss the rigid explanation of this. So sa confession, illustration, the accused was charged with homicide. And during trial, he acknowledged that he was the one who killed the victim. Yan yung judicial confession. The confession was made in the course of trial. Wala nang paligoy-ligoy. Ikaw na nag-plead guilty ka na. And you already confessed, you stated and testified everything what happened, and all are in conformity to your responsibility and accountability as the sole perpetrator of the crime. And while the admission, here is the illustration, the accused was charged with homicide. During trial, he acknowledged that he owns the murder weapon but did not acknowledge that he was not the one who committed the crime. Pinaligoy pa. Sinasabi niya it was self-defense. Diba? To acknowledge ownership of the murder weapon is an indirect acknowledgement of guilt, because an owner of the weapons used in committing the crime is presumed to be the perpetrator. Diba? Let's say for example, kung yung nanakaw na item na nahuli sa'yo, the presumption there is you are the author. Ikaw yung thief. Okay, so you cannot deny it. The evidence itself will tell you that you are the responsible and sole, accountable and responsible to the crime, on the crime committed. Okay, hindi ka na na-acknowledge. But I'm referring yung judicial admission versus judicial confession. Napansin niyo na kung ano yung pinagkaiba. If you did not understand, you can play back this video. Okay, so take note, confession and admission have two kinds, and they are the following. Diba? Meron tayong judicial confessions or judicial admissions, and both are done in open court or during the course of trial. Okay? In the presence of judge. And then extrajudicial confession or admission, both are made outside trial. Okay? Hindi siya kasama. Let's for example, in the investigation done by the police officer. Okay? Everything na sinabi mo, kahit na mayroong counsel doon sa under investigation ng mga PNP, police officers, they are still extrajudicial. Okay? Extrajudicial. Basta lahat ng ganap sa investigation. Okay, let's say for example, ako na iniimbestigahan sa loob ng opisina nila, under ng investigation room nila, lahat ng mga sinasabi ko, whether admission or confession, both are under extrajudicial. Pero lahat ng aking sinasabi naman sa korte, in the presence of a judge, either judicial admission or judicial confessions. Okay? Either confession or admissions, they are under judicial. Under judicial. Okay? I may somehow discuss this to yung judicial, extrajudicial once we are in the court. That would be a part of your final term. So here are the instructions during your exam. Okay, your examination, the coverage of your examination will cover from everything that we had tackled until our last discussion today. Again, from the start of our discussion until the last discussion, including yung pinanood ko sa inyo, yung videos. Okay? Everything that it has been sent, discussed, okay, by orally by me and by my video, are all coverage of your examination. Okay, so what is the set or what are the sets of my examination? Multiple choice, identification, modified true or false, or yes or no. Ayan. I do not give enumeration here. And the way I make exam is it's situational type so that you will not attempt to look at on your notes. Perhaps yung mga yung mga terms ko, yung mga objective type, it is being replaced. Okay? So do not you better understand yung mga definition. And most likely, ang sinasama ko doon sa exam ko ay yung mga discussions ko. If I like I said, yung discussion ko will supplement the notes that you have. Okay? I do not stick only on the notes. Sir, bakit po ganon? Sa notes na, bakit wala sa notes? Are we going to limit ourselves in the notes? We need to expand. And if because me, I'm also expanding the sources. That is for you. Pag you are bombarded with a lot of knowledge, the chances that you can pass the board licensure examination, diba? And when will be our examination? That will be on November 6. We will start our examination at exactly 4 o'clock. Okay? 4 o'clock until 6 o'clock. So that would be a 2 hours duration of your examination. Like I said, again, November 6 is our examination. November 6, that is Saturday. Our exam is 6 o'clock. Be there at you need to join the synchronous class. Sabay-sabay na kayo. Lahat ng sections, regardless kung anong sections nyo, sabay-sabay kayo mag-exam. And you need to enter Zoom. Okay, this is to ensure that everyone is what we call is using, are doing it honestly yung pag-i-exam nyo. Either Zoom or Google Meet yung gagamitin ko. Okay? So that everyone may pakita ko na you are doing it right. And do not attempt to ask your classmates or send your answers. Yan yung pinagalitan ko, ha? Okay? Lahat kayo, sections kasi pinagalitan ko yung section na nagsasendan ng mga sagot. Ginagamit yung messenger. At sabihin pa, mababait. Hindi mababait ang mga yan. Cheaters ang mga yan. Okay? So, all my instructions andito naman. Same instruction pa rin yung pagkuquiz nyo. Okay? I will give, please read the instructions. Again, please read the instructions. Not following the instructions of each set of the exam may tantamount to the tantamount where your score will not be credited or will not be given credit rather. Okay? So you need to read the instruction and you will need to enter the conference class 3:45. Yes, because at exactly 4 o'clock, I will now start. Just a short instruction, then you will start. You will start. How many items? Okay, you will find it once you are now taking the exam. Okay. Again, your examination is November 6 at 4 o'clock. We'll start our exam 4 o'clock, but you need to enter at 3:45. And we will end our exam 6 o'clock. So may trabaho kami. May exam tayo. Yun lang mga masasabi ko. Okay? And then we will have a quiz also at Saturday. I will be posting Google form. Okay? But just wait for the announcement. We will have quiz pertaining on the discussion from the previous post, yung part 1. Ito naman ay na-covered niya rin, though it was added. Again, see you soon and have a great day. Please read and read until nothing left to be read. Okay, so again, the coverage of our exam will start from the beginning until the end of our discussion. That will cover also those videos or the YouTube na available sa aking channel. Thank you so much and God bless.